Let's begin with breaking updates coming in. A significant development. The Supreme Court has held that storage of child pornographic material is an offence under the POCSO Act. The bench comprising CJI Chandrachud as well as Justice Pardiwala set aside the decision of the Madras High Court judgment, which declared that mere downloading and viewing child pornography without the intention to transmit is not an offence. So, observing that the High Court had made an egregious error in quashing criminal proceedings, the Supreme Court has now set it aside and criminal prosecution, the top court, in fact, also suggesting that the Parliament must amend the term child pornography with the term child sexual exploitative and abusive material. Let's go across to legal editor Harish Nair joining us on the broadcast. Harish, take us through what happened in the top court.
Yes, Pratibha, a big landmark judgment as turned by Chief Justice of India as far as the child pornography issue is concerned. The Supreme Court has ruled that even downloading and watching child porn is also an offence under the POCSO Act and also the Information Technology Act, just like creation, dissemination and also publication, transmission and dissemination for gain or attaining some advantage is also an offence. So a very very significant judgment, because Supreme Court has set aside the Madras High Court judgment, which the Supreme Court has termed as atrocious. The Madras High Court had acquitted an accused who had downloaded and watched child pornography and made business out of it, saying that merely downloading and watching is not an offence, and but Supreme Court said that all these are an offence, not only downloading and watching, but also just like creation and dissemination for gain, and also use of children for making pornographic material. So all these are very important. In fact, I'm joined by the lawyer for the NGO which had moved the Supreme Court. Fulkar sir, how significant is today's judgment?
It is very significant. This is in the world, this is the first time that a judgment of this kind examining the whole issue and expanding also the scope of the child pornography. They say it don't convey the exact meaning. So they say instead of child pornography, the term of child sexual exploitative and abuse material. So it expands it. It's not only the porno, but even if it's any kind of sexual abuse material.
What is the exact reason why the Supreme Court has set aside the Madras High Court judgment?
Because Madras High Court says that merely watching a child pornography material or child sexual abuse material is not an offence. The Supreme Court has called it a egregious judgment, and they say it's absolutely wrong. Even watching the child sexual pornography is itself an offence, and if a person by mistake has downloaded, he should immediately delete it, and if he is retaining it and watching it, it's itself an offence. Yeah. Though there are offences of different kind, but that itself is an offence. So they have set aside the order of Madras High Court and have laid down the directions, have laid down the suggestions to the government, have said that the counselling rehabilitation of the victim should be done, is in the school syllabus should be introduced.
Harish, I request you to stay on with us. We have Mr. Priyank Kanungo joining us on the broadcast on the significance of this verdict by the Supreme Court. Mr. Priyank, this is very important and significant. The Supreme Court saying that the storage of child pornographic material is also an offence under the POCSO Act.
Actually, Honorable Supreme Court has upheld the provisions of POCSO Act, which were already there in the well-written, well-drafted Act by Government of India. However, unfortunately, in the order of Honorable High Court of Madras, the significance of implementation of this Act was compromised. Now, by this verdict, it is upheld, and each and every provision of POCSO Act has been upheld by the Honorable Supreme Court. Especially, Honorable Supreme Court has mentioned the suggestion given by NCCR to the Honorable Supreme Court in this case. A special thanks I would like to mention for Honorable Supreme Court for for providing specific space for the suggestion, especially that the information regarding CSAM currently social media intermediaries are providing to only LICMIC, which is a US-based NGO, and NCPCR is opposing it right from the beginning that as per the provision of Section 19 of the POCSO Act, it should be reported to the concerned local police authority. Honorable Supreme Court has mentioned this particular suggestion in the entire judgment. So I am happy with that. I am happy that Honorable Supreme Court has categorically told that the order passed by Honorable High Court of Madras is set aside and trial needs to be started against the concerned accused.
Okay, all right. In fact, Mr. Kanungu, the top court has also suggested that the parliament must amend the term child pornography and it should be replaced with the term child sexual exploitative and abusive material. In fact, it has also requested the union to bring an ordinance to bring in this amendment.
Court, that is also a welcome move by Honorable Court.
Okay, all right. You welcome it. Thank you for joining us, Mr. Priyank Kanungu. Let's go back to my colleague Harish Nair. But before that, my colleague Sagrika is also joining us on the broadcast. Yes, Sagrika.
Pratibha, I'm just going to read out some important excerpts of the 200-page judgment that has been accessed by our legal editor, Harish. And in page number 197, the judgment says that the parliament should seriously consider to bring about an amendment to POCSO for the purpose of substituting the term child pornography with that of child sexual exploitative and abuse material, that is CSEAM, with a view to reflect more accurately on the reality of such offences. The Union of India, in the meantime, may consider to bring about the suggested amendment to POCSO by way of an ordinance. A very big and a landmark judgment here coming in. Then there is also a direction given to courts. We put the courts on notice that the term child pornography shall not be used in any judicial order or judgment. So just taking away the word child pornography, that term itself, the Supreme Court has said, should be substituted, and they are saying that instead the term child sexual exploitative and abusive material should be endorsed. Implementing comprehensive sex education programs that include information about legal and ethical ramifications of child pornography can help deter potential offenders. The program should address common misconceptions and provide young people with a clear understanding of consent and the impact of exploitation. So these are some of the guidelines that the Supreme Court has also mentioned in its order. They've also spoken about identifying at-risk individuals earlier, implementing intervention strategies for youth with problematic sexual behavior, involves several steps and requires a coordinated effort among various stakeholders, including educators, healthcare providers, law enforcement and child welfare services. Educators, healthcare professionals and law enforcement officers should be imparted training to identify signs of PSB. Awareness programs can help these professionals. Now let's take you through the significant part of this order. In the final order, the Supreme Court has mentioned, and I would like to read from the court judgment, for all foregoing reasons, we have reached the conclusion that the High Court, here it's the Madras High Court, committed an egregious error in passing the impugned judgment. We are left with no other option but to set aside the judgment and the order passed by the High Court and restore the criminal proceedings by the Special SC number 170 of 2023 to the Court of the Sessions Judge, that is Mahila Niti Mandaram, Tiruvallur District. We accordingly pass such an order. So an extremely significant judgment here coming in, major steps being taken in an attempt by the courts also, and passing this order to and asking the parliament also to bring about these amendments.
Okay, all right. Sagrika, thank you for joining us. In fact, it also set aside the decision of the Madras High Court judgment, which had declared that mere downloading and viewing of such content without intent to transmit is not an offence. So, Harish, the Supreme Court has now ruled that downloading and watching child porn is also an offence. But what are the guidelines and the legal consequences that we're looking at now that it is going to be an offence under POCSO?
Yes, that's right. The three big takeaways is that, in fact, Pratibha, number one, in fact, downloading, storing and watching child porn is an offence under the POCSO. Number two, also, the Supreme Court has reiterated that creating a child porn video and disseminating, publishing and also transmitting is also an offense. Number 3, most important, if it is known that the particular person who created the video wanted to make some economic gain or benefit, that is a more grave offense. And the biggest takeaway is that Supreme Court has widened the ambit of what is called the child pornography, saying that henceforth it should be called child sexually abusive and exploitative material. If there is proof that a particular child is, there is an attempt to exploit the child, that also comes under this Child Pornography Act definition. So by widening the definition of child pornography, it says from henceforth it should be called child sexually abusive and exploitative material. And very significantly, the Supreme Court has also said that henceforth even the courts should not be using the word child pornography and should be using child sexually abusive and exploitative material. And what is significant is that Supreme Court has restored the criminal proceedings against the particular accused who was acquitted by the Madras High Court, noting that downloading and watching the mere downloading and watching child pornography is not an offense. So Supreme Court has termed that particular judgment as atrocious and has said that and has called for all such child victims who have suffered porn videos, that they should be tracked and given counseling and to come out of that particular shock.
Okay, all right. Big judgment by the top court. Harish, thank you for breaking it down for us and speaking about the significance of it. We're getting in some breaking updates now coming.